Please be seated. The sitting is resumed. Je donne maintenant la parole au...
I now give the floor to Professor Pierre Dargent. You have the floor, Professor. I thank you, President. President, members of the court, it is always an honor for me to take the floor before the court. And it is an honor to do so today, once again, to support the Gambia for such a serious and important case. I will be tackling the matter of the impunity of the masterminds and perpetrators of the clearance operations. Because, as you will see, it is deliberate and organized by Myanmar, this impunity shows its dolus specialis. It will be the focus of my presentation. Also, this very impunity amounts to a sustained breach of the obligation to punish acts of genocide, and Ms. Jones will speak to that tomorrow. Mr. President, because a breach to the obligation to punish genocide can be at issue only if genocidal acts have been committed, Myanmar purports that the Gambia's reasoning is logically flawed when it suggests that impunity is an indicator of dolus specialis, whereas it is up to the applicant to establish that genocidal acts have been committed, which suggests the existence of a very intention, or require, rather, the existence of such an intention. Members of the court, the Gambia naturally sides with the court's jurisprudence and agrees that the obligation to punish genocide can not be breached if there is no genocide. However, when the Gambia alleges that Myanmar's deliberately organized impunity of the members of its military involved in the clearance operation is a key factor allowing to come with even greater certainty, were that to be necessary, to the conclusion that it possessed genocidal intent, when it says this, the Gambia's logic is certainly not flawed. Quite the contrary. Our reasoning here is common sense, just as is that of the UN's fact-finding mission when it took it on and considered that the absence of credible criminal prosecution, not even on the basis of common law provisions, to be the seventh and final indicator of genocidal intent. Indeed, members of the court, as you know, enacting punishment is an attribute of sovereignty and a sovereign prerogative par excellence. Therefore, not to punish when there are clear reasons to take legal action undoubtedly shows the will, the intention of the highest level of the state. The former agent for Myanmar in this case, who is now a prisoner of the junta, she understood this full well, since she said before you, and rhetorically, the following question in the hearing for provisional measures, and I quote her.
On the part of a state that actively investigates, prosecutes, and punishes soldiers and officers who are accused of wrongdoing.
End quote. Mr. President, members of the court, the parties actually agree on the starting point of my analysis, and that is that Myanmar's constitution provides that members of the armed forces can only be subjected to legal action and punished by military courts. What's more, the Commander-in-Chief of the Armed Forces, who was also the head of state, General Min Aung Hlaing, is the supreme judicial authority within the Tatmadaw. His decisions when it comes to military justice are definitive and without appeal. What's more, the Tatmadaw's military justice system is well organized, and once again, I quote the former agent for Myanmar.
Advocate General in Myanmar is by all standards well-resourced, with more than 90 staff and a presence in all regional commands throughout the country.
In other words, the military justice system is in the hands of the military, and that system is fully capable of enacting its authority everywhere where the armed forces are deployed in the country. And thus, as you have just heard Ms. Alamin say, the highest-ranking magistrate of the army, Judge Advocate General Aung Hlin Due, went to northern Rakhine State in 2017, not to inquire, but to aid in the concealment of evidence of the atrocities committed against the Rohingya. Members of the course, Myanmar's setting up of a veritable impunity system which reveals its dolus specialis becomes clear when we analyze its behavior chronologically. And here I would distinguish between three periods of impunity. The first period of impunity starts during the first wave of clearance operations and continues throughout the time period between the two waves of clearance operations. The impunity that followed the first wave guaranteed to military staff who would take place in the second wave that they would be able to take part in it without their having to fear any repercussions. A second period of impunity started at the beginning of the second wave of the operations on the 25th of August 2017 and ran up until the institution of the present proceedings on the 11th of November 2019. Finally, there was a third period of impunity, or rather there is one. It started with the season of the court and runs up until today. Myanmar's behavior during this last period was of course tainted by the present case, since the respondent naturally wishes to appear before you in the best possible light, whereas its fundamental position has not changed in the slightest. Mr. President, members of the court, Myanmar does not dispute that it commissioned no inquiry and initiated no criminal prosecution against members of its security forces involved in the first wave of clearance operations while they were happening, that is to say, between October 2016 and February 2017. This impunity continued between the end of the first wave and the beginning of the second wave in August 2017. However, already during this period, by setting up so-called commissions of inquiry, which were smokescreens, Myanmar tried to put up a front for the international community, which was moved, quite rightly, by the indiscriminate violence that had been waged on the Rohingya. On the 26th of October 2016, the Rakhine State Parliament set up a commission of inquiry made up of 11 members of the parliament of that state. Interviewed by the BBC on the 7th of November 2016 on the pervasive and well-documented rapes of Rohingya women during these operations, the president of this Commission of Inquiry, Mr. Aung Hlin, responded with clear disdain for the victims that such actions could never have taken place because, according to him, Rohingya women
dirty. The Bengali women have a very low standard of living and poor hygiene. They are not attractive. So neither the local Buddhist men nor the soldiers are interested in them. The
court will therefore not be surprised to hear that the report of the so-called Commission of Inquiry of Rakhine State, dated 27th November 2016, stated that no wrongdoing had been carried out by the armed forces and the police during the first clearance operations. At the same time, in December 2016, Myanmar set up yet another smokescreen under the form of the Commission of Inquiry on Mang Do. which was asked to shed light on the attacks of October and November of the same year that had targeted the Rohingya. Made up of 13 members, this commission was presided by General Mint Swe, who was the vice president of Myanmar at the time, and a former head of the Army Intelligence Services. All other members of the commission were appointed by the military authorities. Among them were the head of police, Brigadier General Zor Win, and a former general of Tatmadaw, Mr. Aung Chi. During the first meeting of this commission of inquiry, its president set the tone. Faced with critical reports stemming from international organizations, their job was to reduce their worries and to work swiftly. Thus, on the 3rd of January 2017, less than a month after it was set up, the Mongdo Commission published a brief intermediate report. The so-called attacks against the security forces of Myanmar were described in great detail. However, when it came to the external allegations, quote-unquote, according to which genocidal violence and rape had been committed by the security forces, the Commission simply and briefly stated, following official narratives, and all the while claiming to have carried out special investigations, this commission stated that the presence of the Bengali population, just as the supposed increase in the number of Muslim scholars and mosques are, and I quote,
of genocide and religious persecution in the region.
When it comes to accusations of rape, torture and arson, the Commission fully trusted the security forces, and I quote,
Responsible security personnel performing their duties in those villages submitted that they have been ready to take legal action against those who committed crimes if there was sufficient evidence.
For rapes especially, the Commission decided to allay the concerns of the international community, as its president had announced, and it stated, and I quote again,
Interviewed local villagers and women by using various methods and didn't find sufficient evidence to take legal action up to this date.
In actual fact, these interviews were completely biased. Witnesses were interrupted when speaking, and their words were distorted by the interpreters, as the UN's independent inquiry mechanism for Myanmar has clearly shown. The final report of the Mangdal Commission, who were not independent and they had a lack of an effective methodology, as was pointed out by observers, this report was filed on the 8th of August 2017. The Commission said it had carried out
allegation of rape, torture, arson, human rights violations, discrimination, and even genocide in Muslim villages. Fin de citation.
End quote. Members of the Court, the report of this supposedly detailed inquiry only makes up 7 paragraphs, from the second half of page 8 to the beginning of page 12 of the report. I would encourage the Court to read those pages, which appear in Annex 149, Volume 6 of Gambia's memorial. It says there, systematically, that accusations made against the security forces could not be confirmed, that some allegations described in the same terms will continue to be looked into, and that for others action was taken
Sans autre précision.
with no further precisions, whereas further allegations would require further inquiries but are not further detailed, and we do not know if they were carried out.
Quelques mois plus tôt, le 9 février 2017, à la fin de la première vague des opérations de nettoyage et sur suggestion de la commission de Mangdao, la Tatmadaw créa une prétendue commission d'enquête dirigée par l'inspecteur.
May I interrupt you?
Sorry. Yes, my apology. As I said, a few months earlier, on the 9th of February, at the end of the first wave of the clearance operation, and at the suggestion of the Mongdo Commission, the Tatmadaw set up an alleged inquiry board headed by Lieutenant General A. Win, Inspector General of the Defence Forces, made up of 5 members, all members of the military. Between the 10th of February and the 4th of March 2017, that is over 23 days, the Commission claims it interviewed 2,875 inhabitants of 29 villages in Mangdao Township. On average, that is 125 villagers a day at the very least. That is truly extraordinary. In fact, it is either false or perfunctory. On the 23rd of May 2017, 3 months before the clearance operation resumed, the findings of the investigation were announced. 12 of the 18th accusations to be found in the flash report dated 3 February 2017 from the Office of the United Nations High Commissioner for Human Rights on the basis of interviews of Rohingya refugees in Bangladesh who had fled since the 9th of October 2017. 12, as I was saying, of these 18 accusations were totally wrong. The other 6 were
to false accusations and exaggerations.
No details were brought forward to substantiate these peremptory conclusions, yet the Commission of the Tatmadaw did bother to share these or a number of exceptionally serious facts which really required and deserved to be shared. I'll let you judge this. One soldier had used a motorcycle without the owner letting him do it, while another 3 individuals had been sanctioned for beating a village administrator. So there you have it. There you have it, members of the court. That is how Myanmar, on the eve of the second wave of clearance operations, that is how Myanmar handled the violence unleashed by its security forces in the first wave. Quite clearly, the highest authorities in the state and the highest army officials intended to cover up the abuses. In so doing, the authorities were approving them. But in giving impunity to the perpetrators in the process, it is difficult to state that Myanmar was not also sending a message that they would be fully covered by impunity in the second phase of operations that would be visited upon the Rohingya people. On the 24th of August 2017, that is the day before the beginning of the second wave, the Advisory Commission on Rakhine State, established by Myanmar and chaired by former Secretary General Kofi Annan, made its final report public. And as it had in its interim report a few months earlier, the Commission had insisted that the situation stemming from the first wave was in fact a genuine humanitarian and human rights crisis. And the Annan Commission was clearly not taking seriously the so-called investigations I just mentioned, but underlined that the security forces had to be held accountable for the serious human rights abuses and mentioned a significant risk of renewed violence.
Il n'est malheureusement guère étonnant que les recommandations de la Commission Annan en matière d'enquête et de lutte contre l'impunité.
It is not surprising that the recommendations of the Annan Commission were, as concerns investigations and the fight against immunity, were basically ignored by Myanmar, as you will see. Myanmar, in fact, claims and pretended to implement them, however. And on the 10th of July 2017, even before the Commission filed its final report, the government spokesman, who was Director General of the Office of the President, also stated,
From the international community, we say we are taking action in line with the recommendations of the Kofi Annan Commission. The Commission is serving as a shield for us. Was it not for the Kofi Annan Commission, the allegations would be much worse.
The message, quite clearly, was well understood by the members of the Tatmadaw. As you heard, they would redouble in ferocity in their destructive endeavour over the course of the second wave of clearance operation. And from the beginning of that second wave, 25th of August 2017, until the filing of the application on the 11th of November 2019, Myanmar did not really change its attitude as concerns impunity. And yet, over the same period, the international community repeatedly called on Myanmar to put an end to the abuse and the systematic impunity of Tatmadaw. More specifically, on the 11th of September 2017, the Human Rights High Commissioner called on Myanmar to end its current cruel military operations with accountability for all violations that have occurred. On the 6th of November 2017, the chairman of the Security Council of the United Nations stated once again that the importance of undertaking transparent investigations into allegations of human rights abuses and violations, and to provide justice for victims. On the 5th of December 2017, the Human Rights Council, which, and you'll remember, established the IIMM in March of that very same year, the Human Rights Council, as I was saying, called once again on Myanmar to, and I quote, end impunity for all violations, in particular those perpetrated against persons belonging to the Rohingya Muslim community, end quote. At the same time, a number of states were calling on Myanmar to put an end to the abuse and to investigate in a credible and transparent manner, which clearly hadn't happened until then, and which was also condemned by a number of NGOs of repute. On the 22nd of December 2018, the UN General Assembly shared its, and I quote, grave concern at the findings of the independent international fact-finding mission on Myanmar, according to which, in September of that year, there is sufficient information to warrant prosecutions for genocide, as the mission had identified the highest Burmese military officials in this respect. Myanmar didn't act, or rather, it went ahead and went on with its diversionary operations, thus further strengthening impunity. On the 12th of September 2017, during the second wave of clearance operations, Myanmar established a committee supposedly tasked with implementing the Annan Commission's recommendations. This committee was made up of 18 members representing the government and the presidency. The committee published a 19-page report in June 2019. It stated, without further detail, that the police forces in Rakhine State were operating within the law and were investigating whenever violations occurred. The committee also stated that the Myanmar Human Rights Commission had received complaints and was investigating. The National Human Rights Committee is dependent on the military authorities, and it seems not to have conducted any investigation leading to prosecutions. On the 14th of December 2017, an advisory board made up of 5 international members and 5 national members was established to assist the national 18-member strong committee tasked with the implementation of the Annan Commission's recommendations. Amongst the members of the foreign or international members was Ambassador Bill Richardson, former US ambassador to the UN. He then resigned a few weeks after his appointment. He stated that he did not want to take part in a mechanism which he said was likely to be called upon to become a
quad for government policy.
A few months later, another member of the committee, Ambassador Gopsak Chutikul, a Thai diplomat, also resigned from the advisory board, having denounced in even clearer terms the hoax that all the commissions, successive commissions and boards established by Myanmar they had all been set up for show, all for show, as he said.
En octobre 2017,
and the show went on. On October 2017, the army was establishing yet another internal inquiry board on the second wave of military operations, there again chaired by General I Win. And the commission was once again only made up of members of the military. And once again, it showed extreme zeal and interviewed, this time round, no fewer than 3,217 villagers in 26 days. It filed its report on the 17th of November 2017, that is 1 month after the establishment of the board, and the board found, perfectly predictably, that all security members, up from the leaders to the privates, were aware and strictly abided by the orders and directives of superior bodies. Rather emphatically, this so-called inquiry board stated that there was no death of innocent people, that not a single shot was fired on them, and that, and I further quote, security forces did not commit shooting at innocent villagers and sexual violence and rape case against women. End quote. Yet, 2 months later, on the 11th of January 2018, the very same investigation board set up by the Tatmadaw had to backtrack on its peremptory denialist report. In the meantime, and as Mr. Chai said yesterday, Reuters journalists had revealed the killings of 10 villagers in Din, and as you heard, they may have been killed in revenge. The Armed Forces Inquiry Board further explained that as it was impossible to take 10 alleged Bengali terrorists all the way to police stations during the military operations, it was decided to eliminate them at the village cemetery. Following this massacre, 7 members of the armed forces were court-martialed and sentenced to 10 years hard labor. But barely 7 months later, they were pardoned by the head of state and released.
chef de l'État. Cette grâce présidentielle, mesdames et messieurs les juges,
This presidential pardon, members of the court, comes in sharp contrast with the fate that awaited journalists of the Reuters agency who published the undeniable photographic proof of the summary execution of those 10 villagers. Photographic proof that you will find in tab 4 of your file. Myanmar arrested the journalists, and on the 3rd of September 2018 they were sentenced to 7 years of detention. This sentence was confirmed by the Supreme Court. It was only following massive mobilization by the international community that the journalists were freed on the 6th of May 2019 after having spent a year and a half behind bars. That is to say, twice as long as the 7 months that the killer soldiers spent in prison. To respond to the so-called false allegations that were growing after the work of the fact-finding mission, Myanmar set up on the 30th of July 2018 an independent commission of inquiry. In actual fact, this commission was absolutely not independent from the government. Its very mandate stated that it was charged with inquiring about human rights violations and I quote, following the terrorist attacks by the Arakan Rohingya Salvation Army. The president of this commission set the tone when she said, and I quote, there would be no seeking of accountability. There will be no blaming of anybody, no finger pointing of anybody, because that wouldn't achieve anything. We wouldn't achieve anything by that procedure, and that would only give rise to quarreling. The president confirmed that interviews were carried out in the presence of security forces. What's more, one of the 4 members of this commission, Mr. Tun Tet, was the head coordinator of the Union Enterprise for Humanitarian Assistance, Resettlement and Development in Rakhine, and had supervised bulldozing of Rohingya villages. Before joining this so-called Commission of Inquiry, so-called Independent Commission of Inquiry, he had stated in March 2018 that Myanmar, and I quote, had a clear conscience, and that in his country there is no such thing as ethnic cleansing and no genocide. In sum, this is Myanmar's response to the atrocities committed in the second phase of the clearance operations. I now come, members of the court, to the third period of impunity, that which started when the court was seized. The efforts of Myanmar may appear to you as those of a state wishing to abide by its obligations to inquire and prosecute, but if we look at this, we find that these efforts can be unmasked and taken apart. What matters here, it's not the different condemnations of or sentencing of so-called terrorists. What matters is the prosecution, or rather lack thereof, against members of the forces, of the security forces. And we should look on the one hand at its police officers and on the other at the military for their behavior in the clearance operations and not in other contexts. Regarding the police officers, Myanmar explains in the final report of its Independent Commission of Inquiry that it set up in January 2020 the Criminal Investigation and Prosecution Body. In its first report following the order of the court in January 2020, Myanmar pointed out that amongst the 139 cases identified by its Commission of Inquiry, 23 bore on members of its border police. This figure hasn't changed since. That was nearly 6 years ago. The evolution of the status of these 23 cases is presented in the semestral report of Myanmar. The tally of the 5th report in May 2022 has remained identical up until the latest report in November 2025. And here's the outcome. 7 inquiries that were ended for lack of evidence. 8 inquiries closed because the accused are allegedly on the run. 6 inquiries presumably continuing since May 2023, but with no news about them, and 2 cases leading to sentencing. These 2 cases only had to do with lack of discipline. The punishment given to the policemen was a mere loss of 2 years of seniority for the purpose of calculating their pension. And that is just for the prosecution of police officers since the seizure of the court.
As concerns prosecution of members of the armed forces, the Independent Inquiry Board identifies at most 13 serious incidents. The first one, identified by Reuters journalists, concerned the massacre of the 10 villages in Indin. I mentioned that, and you know that all eventually led to the pardoning and releasing of the servicemen 7 months after the beginning of their sentence. Second incident, the village of Gudapin, which Mr. Njai mentioned yesterday. 18 days after the application by Gambia was introduced, a court-martial rather conveniently heard the case relating to these facts dating 2.5 years. the court-martial sentenced a junior officer to 1 year in prison for breaches of the rules of engagement. One officer was also sentenced to a year for breaches of duty as a superior, whereas a higher officer was also sentenced for breaches of duties of command and lost 1 year of seniority for the calculation of his pension. In its 2020 report, Myanmar also indicates that it started investigation for the crimes committed in Chutpin and Mang Nu, which Mrs. Ho and Ms. Gum mentioned and described yesterday afternoon. As concerns the events in Mang Nu, the investigation led to the sentencing of one officer for breach of duty, which meant that he lost 1 year's pension right. 2 other junior officers were sentenced to 1 and 2 years in prison for robbing Rohingya women and doing so while resorting to violence. The 565th Infantry Battalion was fully and collectively cleared of any involvement in the incident at Tang Bazar in the vicinity of Mang Nu. The investigations relating to Chutpin have not led to any prosecution. I suppose that means these are allegedly still active. And since its third report in May 2019, when not referring to the pandemic, the retiring of the lead investigator, or the security situation, Myanmar explains that the witnesses must first be repatriated so that the investigation can move forward. But you may wonder, however, why no members of the military were interviewed, and have been till now. Mr. President, members of the court, can I quote once again the former agent of Myanmar?
State that actively investigates, prosecutes, and punishes soldiers and officers.
The question then was a rhetorical one. You now know what the answer to that question is. You will draw the conclusions, the right conclusions. Myanmar didn't actively either investigate, nor truly prosecuted, nor really punished the many soldiers involved in these operations of unprecedented destructive cruelty. And at all times, Myanmar ensured the full impunity of the masterminds of the abuses. Myanmar was therefore indeed driven by genocidal intent. This conclusion, members of the court, is reinforced by the fact that Myanmar, rather than prosecuting and punishing them, Myanmar has in fact promoted some of these officers involved in the clearance operations, especially the officers commanding the units responsible of the worst sexual offences, as the IIMM highlighted. I'd like to thank the court for its kind attention and request, Mr. President, that you call Mr. Suleiman to the podium. I thank Professor Dazan for his statement.
I invite Mr. Arsalan Suleiman to address the court. You have the floor, sir.
Mr. President, members of the court, you have heard the excruciating details of Myanmar's genocidal clearance operations and the many indicators of genocidal intent associated with their planning, organization, and brutal execution, and the failure to punish any of the perpetrators who continue to enjoy absolute impunity. Myanmar's defense is that it was carrying out legitimate counterterrorism or counterinsurgency operations. As the evidence shows, that is demonstrably false. Myanmar's clearance operations were the antithesis of legitimate counterterrorism operations. First, I will discuss the many reasons why the clearance operations, which Myanmar claims to have been directed against ARSA, the Arakan Rohingya Salvation Army, were not legitimate counterterrorism operations. Then I will demonstrate the same by comparing the anti-Rohingya clearance operations with Myanmar's operations against the Arakan Army, the rebel faction composed of ethnic Rakhine Buddhists, and with Myanmar's operations against ethnic separatist groups in other regions of the country. Next, I will show that Myanmar's evidence is unreliable and not entitled to evidential weight. And finally, I will address Myanmar's arguments regarding the context of the clearance operations. The defining features of Myanmar's anti-Rohingya clearance operations cannot reasonably be explained by an intent to counter terrorism because those operations violated the fundamental tenets of legitimate counterterrorism operations. The court has the benefit of two expert reports from Professor Michael Newton, a respected legal scholar, former military officer, and specialist in international law related to armed conflict and counterterrorism operations. The court also has an affidavit from Professor Newton, and we'll hear from him directly next Thursday. As Professor Newton explained in his reports and affidavit, the fundamental tenets of legitimate counterterrorism operations include: 1, a clear distinction between the terrorist or insurgent group and civilians; 2, a focus on providing security to or protection for the civilian population; and 3, strictly following rules of engagement to limit collateral damage to civilians. Myanmar grossly and deliberately ignored and violated all three of these elements in its anti-Rohingya clearance operations. First, it is evident that Myanmar did not distinguish between ARSA's members and Rohingya civilians. The presentations you have heard from my colleagues regarding the conduct of the clearance operations in Mingi, Chutpin, Mongnu, other notable villages, and generally across northern Rakhine State clearly show that the civilian population, innocent and unarmed men, boys, women, girls, the elderly, the infirm, that civilian population was specifically targeted. This is the conclusion of the UN fact-finding mission, which reported that the anti-Rohingya clearance operations, quote, have been marked by an equation between an entire civilian population, the Rohingya, and the non-state armed actor that was the perceived or stated threat. No distinction whatsoever was made between civilians and civilian objects on the one hand, and fighters and military objectives on the other. Everyone and everything was a target. The operations and use of force were not targeted at eliminating a specific and limited security threat posed by ARSA. They were targeted at eliminating ARSA's support base, if not the group, the Rohingya itself. The UNFFM's conclusions are corroborated by other independent sources. For example, the report of the U.S. Department of State also found that, quote, the military, which used the ARSA attacks to justify its so-called counterinsurgency operations in northern Rakhine State, targeted civilians indiscriminately and often with extreme brutality, end quote. Amnesty International, which Myanmar has cited in its pleadings regarding ARSA's actions, concluded in the same report that Myanmar's, quote, unlawful and grossly disproportionate campaign of violence marked by killings, rape, and other sexual violence, torture, village burning, forced starvation tactics, and other human rights violations and crimes under international law, target the entire Rohingya population living in northern Rakhine State." End quote. A joint report by Fortify Rights and the U.S. Holocaust Memorial Museum found that the 2016 clearance operations were, quote, "targeted attacks on a large number of Rohingya civilians," end quote, and that the 2017 operations targeted, quote, "hundreds of Rohingya villages and hundreds of thousands of civilians," end quote. Even the International Crisis Group, which Myanmar cites repeatedly, confirms that the Tatmadaw used, quote, "disproportionate force which failed to adequately distinguish militants from civilians," end quote. But you don't have to rely solely on the considered findings of these independent and credible sources. Myanmar itself admits that it targeted all Rohingya in the villages where it conducted operations. It is Myanmar's position that, quote, "large-scale mobilization of the local community was essential to ARSA's activities," end quote. Throughout its pleadings, as you can see on your screens, Myanmar states very clearly that the clearance operations targeted ARSA, quote, "and its supporters," and its supporters. By its supporters, Myanmar means the local community, i.e. all villagers, no matter their age or gender or their engagement in anti-government actions. You may think my interpretation of Myanmar's position sounds excessive, but Myanmar actually says this in its counter memorial at paragraph 13.214, which you can see on your screens. It states, quote, "The terrorists and supporters comprised men, women, and children. Women and children. And were drawn in their thousands from the local communities. Generally speaking, neither uniforms nor insignia were worn by ARSA terrorists and its supporters, who would not be readily distinguishable from civilians not involved in the ARSA activities," end quote. And children. Children. No wonder so many children were targeted for brutal murder. Myanmar considered them terrorists or their supporters. No wonder so many civilians were brutally slaughtered. Myanmar claims that it could not distinguish civilians from ARSA or those it considered its supporters. So with this outrageous claim, according to which each and every Rohingya is a born terrorist and ARSA lifelong supporter, Myanmar wants you to accept that it was legitimate for its soldiers to indiscriminately attack and kill everyone. After reviewing Myanmar's pleadings on this point, Professor Newton also concluded that Myanmar's own pleadings constitute, quote, an admission that security forces deliberately conflated Rohingya civilians with ARSA and then attacked and destroyed them, end quote. To justify its targeting of civilians, Myanmar will surely assert that ARSA mobilized all the villagers. But that is also false. The UN fact-finding mission confirmed that ARSA remained small and represented no more than a tiny fraction of the Rohingya population. In fact, the sources that Myanmar relies upon so heavily, the International Crisis Group and Amnesty International, both explicitly reject the claim that Rohingya civilians took up the ARSA cause in significant numbers. The Amnesty International report cited repeatedly by Myanmar makes clear, quote, while Amnesty International has confirmed that some Rohingya villagers participated in ARSA attacks, the overwhelming majority of Rohingya did not. Even in the specific villages where attacks occurred, there is no question that most villagers did not take part in ARSA attacks, end quote. Similarly, The International Crisis Group concluded that, quote, not many villagers appear to have joined the attack on the army base in Chin Mar village, end quote. One of the more significant ARSA attacks that Myanmar alleges to have taken place, but, quote, which was quickly overpowered. The report also found that the ARSA commander's call to his followers to burn down Rakhine Buddhist villages, quote, does not appear to have been widely acted upon, as only 3 non-Rohingya villages are known to have been attacked or burned down by Rohingya, end quote. So the alleged massive support for ARSA was actually insignificant. Despite that fact, Myanmar deliberately chose not to distinguish between ARSA and civilians when it carried out the clearance operations. Myanmar also violated the second fundamental counterinsurgency principle of providing security or protection to the civilian population in order not to alienate it. Myanmar has alleged that ARSA was a threat to the civilian Rohingya population. It stated in its counter memorial that, quote, ARSA was responsible for killing many Muslims in the region who worked for the government or were suspected of being informants or collaborators, end quote. It went on to state that ARSA engaged in, quote, attacks on civilians, murders of local leaders, violent threats against both the Muslim and Rakhine communities, end quote. So if Myanmar had been engaged in legitimate counterterrorism operations, then it should not only have distinguished between ARSA and Rohingya civilians, it also should have provided security and protection to the Rohingya civilian population, which it claims was threatened by ARSA. The evidence indicates that it did no such thing. As I presented on Monday afternoon, we know that before and during the clearance operations, Myanmar engaged in a hate propaganda campaign that dehumanized the Rohingya, vilified them collectively as an impure race, as foreigners and terrorists who would swallow up the Buddhist races in Myanmar, and it incited hatred and genocide against them. As explained by Mr. Lowenstein, we also know that before the clearance operations, Myanmar systematically made the Rohingya less secure, not more. They took down protective fencing and confiscated any materials that could have served as defensive weapons, like kitchen knives. Rather than help the local Rohingya communities defend against the so-called threat from ARSA, they focused on making them completely defenseless against the military's wanton violence to come. And we also know from the detailed village-level presentations of my colleagues about the conduct of the clearance operations that the Tatmadaw did not focus on providing security at all. Just the opposite, time and time again, as you have heard. As summarized by the UN fact-finding mission, quote, the operations had a devastating impact on the Rohingya civilian population, which was targeted, brutalized, and terrorized. Rohingya-populated areas across the 3 townships of northern Rakhine State were deliberately destroyed in a targeted manner. Professor Newton also concluded that Myanmar attacked Rohingya civilians rather than taking actions to protect and secure them from ARSA. Beyond destroying Rohingya villages during and after the clearance operations, the evidence shows that even after these operations were conducted, rather than protecting Rohingya civilians and their property, Myanmar sought to erase and replace them permanently. You heard from Mr. Lowenstein yesterday about the findings of the IIMM's September 2025 public summary of its report entitled The Destruction and Dispossession of Rohingya Land and Property During the 2017 Clearance Operations. That detailed report identified 7 representative examples of a systematic pattern in which, quote, the 2017 clearance operations combined land seizure, targeted destruction of livelihoods, and forced displacement to erase Rohingya presence from their ancestral homeland, end quote. The IIMM concluded that, quote, the ubiquity and consistency of these operations, using bulldozers, excavators, and dump trucks to systematically flatten villages across northern Rakhine State, is consistent with an organized campaign aimed at permanently erasing Rohingya presence, end quote. The IIMM found that Myanmar was systematically dispossessing Rohingya of their land and property and foreclosing the possibility of their return. Myanmar was also replacing the Rohingya with more favored ethnic groups. The IIMM reported that, quote, hundreds of new houses funded by regional governments and foundations were handed over to ethnic Mro and Dainet families and recent immigrants from Bangladesh, which, quote, indicate that the Myanmar authorities carried out demographic replacement under the guise of development and resettlement, end quote. There is a separate IIMM report on this topic at Annex 7 of the Gambia's reply, which confirms that Myanmar had a, quote, wider strategy to alter the ethnic makeup of Rakhine State to remove or reduce the influence of Muslims, end quote. The IIMM concluded that, collectively, these acts, quote, created very serious impediments to the ability of Rohingya to ever reconstitute the communities where they had lived for generations, end quote. And that was the point. Myanmar did not even pretend to try to protect Rohingya civilians from ARSA. The goal was always their destruction as a group within Myanmar. Myanmar also violated the third fundamental tenet of counterterrorism by failing to adhere to rules of engagement and to limit collateral damage to civilians. Myanmar's rules of engagement, which were annexed to its counter memorial at Annex 152, reflect standard counterinsurgency doctrine as set forth by Professor Newton. They require, for example, the military to distinguish between civilians and combatants, minimize collateral damage to civilians and property through the use of proportionate force, give advance warning before attack, attack only when necessary to attain the military objectives, do not take or destroy property owned by civilians, and provide special protection for children and women, end quote. But Myanmar did not follow its own rules of engagement. It failed to distinguish between civilians and ARSA. It failed to protect the civilian population. It admitted to including women and children among its military targets. And it deliberately destroyed the villages of the Rohingya civilian population. Furthermore, on its face, the rules of engagement indicate that the mission objective was to quote, counter attacks by AA, that's Arakan Army, and ARSA terrorists, end quote. Period. Not to attack alleged ARSA supporters, not to attack and kill Rohingya civilians, not to destroy their villages and every trace of them. There is compelling evidence from diverse sources establishing that orders were given to Tatmadaw soldiers to kill all Rohingya. These sources include, among others, the following 7. 1, the August 2017 video of the Tatmadaw soldier telling Rakhine civilians, quote, we will be moving around the area, clearing the villages of these animals. We have guns, we have bullets. That's what we came with ammunition and the spirit to attack these animals. We have come here, end quote. Recall from my Monday afternoon presentation that this video was disseminated by the Tatmadaw repeatedly on Facebook to reach the widest possible audience across Myanmar. Second, the IIMM screening note of P5513, a military defector, who stated that, quote, in 2017, the military did not distinguish between fighters of Rohingya armed groups and Rohingya civilians. So they targeted Rohingya as a group, end quote. The accuracy and reliability of P5513's account was attested to in a sworn declaration by IIMM investigator Viral. 3. Two Tatmadaw soldiers who participated in the clearance operations and later defected testified in their video statements annexed to the memorial that they were ordered to kill everyone, men, women, and children, all members of the Rohingya group, without distinction, to, quote, shoot at every sight of a person, end quote. 4. A Tatmadaw soldier from the 33rd Light Infantry Division told the Rohingya during the clearance operations in mid-August 2017 in a village in Rathadong that, quote, the central government sent us specially to kill you Bengali people, end quote. Number 5, Nazmul Islam, a former soldier and ethnically Rakhine man who converted to Islam and was held by the Tatmadaw during its clearance operations in Mingi, stated that a military officer announced, quote, we have the order to kill everyone, end quote. His account, which was published in The Guardian, is confirmed by his video interview annexed to the reply. 6. A witness from Maungnu testified in a sworn statement that he observed a Tatmadaw officer receive instructions by phone, and after hanging up, he told his fellow soldiers, quote, we will kill them. After that, the executions of Rohingya civilians in Maungnu began. 7. Mo Yan Nang, a police captain who was stationed in Rakhine, stated in relation to the village of Indin that, quote, the troops shot into the village before entering. They shot and killed whoever they found in the village, end quote. There can be no doubt that Myanmar purposefully targeted all of the Rohingya population and did not seek to minimize collateral damage. As Professor Newton observes, quote, Myanmar's rules of engagement demonstrate that Myanmar understood and accepted standard counterinsurgency doctrine during the entire period that it was ignoring them in practice, end quote. Mr. President, members of the court, further proof that Myanmar's counterterrorism defense is unfounded comes from comparing Myanmar's counterinsurgency operations against the Arakan army with its actions allegedly targeting ARSA. First, I should note some differences between the two groups. While ARSA is made up of members of the Rohingya group, the Arakan army is comprised of ethnic Rakhine, mainly Buddhists. The Arakan army was founded in 2009 and was active in Rakhine State years before ARSA even existed. Myanmar acknowledges in its counter memorial that, quote, since March 2015, there has in Rakhine State also been an armed conflict between the Myanmar Defense Services and the Arakan army, end quote. And since, quote, November 2018, attacks by the Arakan army intensified in Rakhine State, end quote. The difference in military capabilities between both groups is stark. According to Myanmar, the Arakan army, quote, has a significant military armory, end quote. It, quote, receives arms and ammunition from the Kachin Independence Army and the United Wa State Army, and also purchases weaponry and ammunition on the black market at the Thai-Myanmar border, end quote. The UN fact-finding mission reported that the Arakan army is a, quote, well-trained force that operates under a clear command structure, end quote, and its weaponry includes, quote, sniper rifles, light artillery, and improvised explosive devices, end quote. As confirmed by Myanmar in its most recent Provisional Measures Implementation Report, the Arakan Army has effectively taken over almost all of Rakhine State, including all of northern Rakhine State. In contrast, according to the UN fact-finding mission, ARSA members mostly had nothing but, quote, homemade weapons such as sticks, knives, swords, and slingshots. The mission found that ARSA was a small, poorly organized militia that didn't have the skill or resources to launch an attack that could truly challenge Myanmar's security forces. Most of those considered to have joined the ARSA attacks received no training at all prior to the 2017 attacks. These findings are confirmed by the IIMM's report on, quote, evidence of ARSA's weapons possession and use, which is annexed to the Gambia's reply. The IIMM found that ARSA's weapons were limited and primitive. At the time of the August 2017 attacks, ARSA had only a, quote, modest arsenal of around 40 to 70 firearms, end quote. The majority of ARSA's members used, quote, bladed weapons, sticks, and a small number of locally produced artisanal firearms, end quote. In light of these profound differences between the Arakan Army and ARSA in capacity and level of threat, a comparison of Myanmar's operations against the Arakan Army with its conduct of the clearance operations in northern Rakhine State is especially revealing. Both of these entities operate primarily in Rakhine State. Myanmar considers both of them as terrorist groups. Myanmar conducted so-called clearance operations against both. And most importantly, Myanmar applied the exact same rules of engagement to both. So if we were to assume that Myanmar actually followed its rules of engagement, then the nature of military operations employed against both groups should be very similar, perhaps with some differences to account for the greater military capabilities, weaponry, and organization of the Arakan Army. But this is not reflected in the evidence. To the contrary, we see very clearly the genocidal intent that permeated Myanmar's anti-Rohingya operations. It was only against the Rohingya that the Myanmar military targeted the entire civilian population in village after village where it conducted operations. Only against the Rohingya was there such brutal violence that included the indiscriminate killing of thousands of people, including children. Only against the Rohingya did the military systematically engage in brutal sexual violence. Only against the Rohingya did the military burn down hundreds of villages, taking care not to burn down the ethnic Rakhine villages adjacent to the Rohingya ones. It was only Rohingya land that was confiscated and built over by the state in an effort to permanently dispossess the Rohingya of their land. And it was only the Rohingya who were subjected to discriminatory policies for decades and a campaign of hate propaganda to dehumanize and incite violence against them. All of these factual differences are borne out in the reporting of the UN fact-finding mission, which specifically investigated Myanmar's conflict with the Arakan Army in its 2019 detailed report. While the FFM found that Myanmar committed war crimes in its operations against the Arakan Army, it did not find genocidal intent or similar types of genocidal violence against the Rakhine Buddhist population as it found were perpetrated against the Rohingya. Specifically, the FFM did not find any indiscriminate killing of Rakhine Buddhists, nor did it find that there was brutal treatment, burning of homes, widespread sexual violence, or targeting of children in the Rakhine Buddhist villages. Neither did it find comparable, deliberate destruction of those villages, the forced displacement of the civilian population, or the prevention of their return. In this comparison, the court can find confirmation that Myanmar acted with genocidal intent during its anti-Rohingya clearance operations. These were manifestly not legitimate counterterrorism operations. Additional comparisons outside of Rakhine State can be instructive as well. Myanmar recognizes that since the time of its independence, it has, quote, been engaged more or less continuously in internal insurgencies with various ethnically based insurgent groups in different parts of the country, end quote. According to the UN fact-finding mission, these include the Kachin Independence Army, the Shan State Army South, the Shan State Army North, the Ta'ang National Liberation Army, the Myanmar National Democratic Alliance Army, and the United Wa State Army. In its reporting, the FFM pointed out violations of human rights and international humanitarian law by the Tatmadaw in Shan and Kachin states involving these groups. The United Nations has also had a special rapporteur monitoring the human rights situation in Myanmar since 1992. The reports of the special rapporteur have also focused on violations involving Myanmar's conflicts with various ethnic armed organizations. Even though Myanmar has engaged in counterinsurgency operations against all of these groups over many years, its actions against them have never included the same indicators of genocidal intent as are present in their actions against the Rohingya, from its anti-Rohingya hate propaganda and racially discriminatory policies, through its conduct in the clearance operations and beyond. My next point relates to the evidence that Myanmar offers in support of its counterterrorism defense. Myanmar presents reports produced by the military related to the clearance operations, witness statements from 7 military or police officers, several witness statements from local residents of Rakhine State, and witness statements from 2 alleged members of ARSA who are prisoners in Buthodong prison. None of these sources are credible or reliable. First, the military's own reports show only what the military decided should be reported regarding those incidents. They are not reports from an independent source, nor are they comprehensive as to the events that took place in those villages. Moreover, these reports are contradicted by the evidence from independent and unbiased sources that the Gambia has placed in the record, including the findings of the UN fact-finding mission, dozens of independent NGO reports, and sworn witness statements from eyewitnesses. There is also reliable evidence produced by the IIMM that indicates that Myanmar military reports regarding the clearance operations, apart from being self-serving, were falsified. The IIMM screening note for military defector P5513 states that regarding the incidents in the village of Sin O Pin in Buthodong Township, the deputy battalion commander dictated the information for the incident report. According to P5513, quote, the report stated that ARSA attacked the military and in response they cleared the village, and that when ARSA withdrew from Sin O Pin, they, ARSA, burned down the village. Asked if the contents of the report as dictated were consistent with what P5513 had observed, P5513 stated that the report as written was not factual or correct. It was in fact Light Infantry Battalion 562 who burned down the village. There were no firearms or ammunition. He did not believe that the deceased people were ARSA, but rather they were civilians, as evidenced by the fact that he even saw children amongst the dead, end quote. As to Myanmar's witness statements, they are all purportedly from 2017 or 2019, but Myanmar never explains the circumstances of their production. They appear to have been part of some Myanmar military inquiry, meaning that they were not part of an independent process. As Professor Dargent clearly showed, Myanmar's purported investigations and inquiries were not credible and were part of a system reinforcing impunity for Myanmar's crimes. Any statements created through such biased processes are not reliable or credible. It is notable that although Myanmar listed 3 military officers as witnesses for oral testimony during these hearings, Myanmar ultimately removed all of their names from its witness list. The statements of 2 of those officers are among the statements that Myanmar annexed to its rejoinder. But since Myanmar has not produced them for oral testimony, we cannot question them through cross-examination, nor can they answer questions from the court. Myanmar also submitted witness statements from 2 alleged ARSA members who are incarcerated in Buthodong prison. As Ms. Ho noted yesterday, they are thus completely under Myanmar's control in a prison facility that is notorious for torture and other forms of abuse, as documented in the IIMM's report on evidence related to detention of Rohingya in Buthodong prison and other locations, which was annexed to the reply. As Ms. Ho pointed out, Myanmar's influence on their testimony is readily apparent on the face of their statements. Members of the Arakan Rohingya Salvation Army, it would be odd to say the least that they would refer to themselves as Bengali, the term that Myanmar seeks to force the Rohingya to adopt. Most of the witness statements have been submitted by Myanmar to argue that the Rohingya burned their own villages down. That claim is contradicted by extensive evidence and analysis by the UN fact-finding mission, UNISAT, and the IIMM, all of which conclude that Myanmar purposefully burned the Rohingya villages. The falsity of that claim is also clear, given that Myanmar's efforts to fabricate evidence of such burnings by instrumentalizing the local Hindu community was exposed by journalists. I turn now to my final point, which is that context is not a defense to genocide. Myanmar insists that the context of the clearance operations was ARSA's attacks in 2016 and 2017, and that the Gambia ignores this. Of course, the Gambia never ignored this. You can see, going all the way back to the Gambia's application at paragraph 48, a description of the 9 October 2016 incident by a group of individuals who later called themselves Harakat al-Yaqin, which changed its name several months later to ARSA. And at paragraph 72 of the application, the Gambia stated very clearly that Myanmar's pretext for resuming clearance operations on 25 August 2017 was attacks on a military base and various security outposts by ARSA, carried out largely by untrained individuals wielding sticks and knives, with a small number bearing arms and improvised explosive devices. That same position has carried throughout the Gambia's pleadings. More importantly, as Myanmar acknowledges, the UN fact-finding mission never ignored ARSA. It extensively reported on ARSA and its activities, including its human rights abuses, which Myanmar cites extensively. The IIMM produced an entire report dedicated to ARSA, analyzing its capabilities and the nature of the potential threat it posed. Most of the NGOs whose reports the Gambia cites also reported on ARSA and its abuses. So all of these entities were fully aware of ARSA when they produced their reports and made their conclusions. The fact that ARSA's attacks preceded the genocidal clearance operations does not make it any less valid that Myanmar and its soldiers had the requisite genocidal intent as they planned and carried out their attacks. It is well established that the context of genocidal acts is not a defense to genocide. It is just that, the context. War has been context for genocide. The Holocaust occurred during World War II. The Srebrenica genocide occurred during the Yugoslav wars. The Rwanda genocide occurred during a civil war. Just because the context of these past genocides was war or internal armed conflict did not mean that genocide did not take place. The same is true here. Even if the immediate pretext for the clearance operations was ARSA attacks, that does not negate or excuse the genocidal acts deliberately perpetrated by Myanmar against the Rohingya group in carrying them out. Moreover, the context relevant to this case extends far beyond the ARSA attacks. It includes Myanmar's decades-long persecution of the Rohingya and Myanmar's many years-long campaign of hate propaganda, and all of Myanmar's actions after the clearance operations, including its impunity, destruction of evidence, and the destruction of Rohingya villages. Finally, it is not true that Myanmar's clearance operations were limited to villages where ARSA attacks allegedly took place. You will recall from yesterday that Mr. Lowenstein showed you Myanmar's figure 8.1 from its counter memorial, onto which he overlaid the map of village destruction during the clearance operations produced by UNOSAT, which is figure 1.3 of the memorial. The resulting map, which is reply figure 1.2, shows that most of those green dots where Myanmar asserts no ARSA attacks took place are villages that, according to the United Nations, were destroyed during and after the clearance operations. Myanmar wholly or partially destroyed at least 188 out of the 329 villages where, according to Myanmar, there was absolutely no ARSA presence and no pretense for any counterterrorism operations. Put simply, Myanmar's argument that the clearance operations were only responsive to ARSA attacks is refuted by its own evidence. Myanmar argues that its counterterrorism operations ended on 5 September 2017, but the UNOSAT figures depict villages that underwent fire damage from 31 August 2017 to March 2018. Myanmar admits that some of the village burning happened after the purported end of their clearance operations. This is further proof that Myanmar conducted the burnings. If villages were burned after Myanmar claims that its clearance operations ended, which is when the military had complete control over the Rohingya villages, then it could only have been the military that burned them, not the Rohingya themselves. In any event, when the Gambia refers to the clearance operations, it includes the military activities spanning from late 2016 through 2018, when Myanmar was engaging in further village destruction and confiscation of Rohingya lands. In conclusion, Myanmar's defense of its clearance operations, that it was only engaging in counterterrorism operations in response to ARSA's attacks, is manifestly false and unsustainable. These operations violated all of the fundamental tenets of legitimate counterterrorism operations, including Myanmar's own fundamental tenets as reflected in their rules of engagement. In fact, Myanmar's rules of engagement constitute a powerful and indisputable statement against interest. They constitute a compelling admission by Myanmar of what it should have done if it had intended counterterrorism. In completely disregarding them, in trampling over them, in setting fire to them along with hundreds of Rohingya villages, Myanmar left only one explanation for its actions. Only one reasonable inference that could be drawn from the resulting pattern of conduct, that it deliberately intended to destroy the Rohingya group within Myanmar. Mr. President, members of the court, thank you for your kind attention. This concludes the Gambia's presentations for the morning session. After the lunch break, Mr. Lowenstein will continue the Gambia's presentations.
I thank Mr. Suleiman, whose statement brings this sitting to a close. The oral proceedings in the case will resume this afternoon at 3 p.m. when the Gambia will continue its first round of oral argument. The sitting is closed.
Dibaniki second part of it, but Innovazo Natalan time. Innovazo ile Ara Saudi Arab mare 500 baje, Malaysia mare 800 baje, Bangladesh mare 800 baje area. The live of the Tulium inshallah on rather the Saitamono of the Tigile, Sai Hariba.